Tonight, Thomas is going to talk to us about the decision of the IPEC in Shazam and Only Fools, the dining experience. Specifically, he's going to address the question of the protection in copyright law of fictional characters, as well as the defenses of fair dealing for the purposes of parody and pastiche. So without further ado, Tom, thank you very much for being here tonight. Sorry about the technical issues. And the floor is yours.
Thank you very much, Christina. So good evening again. I'm delighted to be here to give you a lecture very largely about a case I lost on practically every issue. And I hope it's of some use to you and more use than it was to my clients. But an interesting case from a legal perspective in any event. As Christina introduced me, I'm grateful for that. It is a case that's largely about copyrighting fictional characters. And I'm also going to cover the potential defenses that were dealt with by the same judgment. Starting with the fictional characters and their copyright protection. There's surprisingly little authority on this issue historically. And I say surprisingly little because one can easily imagine circumstances in which a novelist or a screenwriter may want to write a new work which takes advantage of characteristics of an existing fictional person. For example, to develop new stories on old grounds and potentially take advantage of an existing audience for stories about that person. And following that, one can then easily imagine circumstances in which the originator, or perhaps more likely their heirs or assignees, would be very keen to stop the person using the original characters that they or their predecessors have created. I've got three theories about why historically the number of cases on this issue may have been quite small. The first is perhaps that there are many other rights in play, potentially other rights in play. So trademark infringement if people have registered rights, or passing off if they do or they don't have registered rights. And one can see, as was also the fact in the Shazam case, although not something I'm going to talk about today, that marketing a new work based on existing characters may well lead to members of the public believing that it was somehow sanctioned, or even that it came from or with the approval of the original author. The second of my theories is that, particularly more recently, a common area in which people want to use existing characters to create new stories is in the genre of fan fiction. So people who are fans of a show write their own stories because they want to explore the universe in which that character or several characters exist. And of course, most publishers, most authors might think twice before they start suing their fans or a body of their fans for what's essentially a complement of their original work. The third possibility, and one that I'll touch on in more detail, is perhaps that the law was thought to be against the copyright owner in these circumstances, that characters perhaps being too abstract for protection by the law of copyright wouldn't by themselves give rise to a viable or successful cause of action against someone creating derivative works incorporating existing characters. And that's where I will now go. So hopefully, now moved everything on the computer. So here we are. Good. So the first case, or a potential source at least, of the belief that protection of characters by way of copyright might have been a difficult thing to do is a case that's now over 90 years old, called Kelly and Cinema Houses. It was a pretty peculiar case. So the facts of it in summary were that there was a Miss Brandon who'd written a play. That by itself, of course, not particularly surprising. An intermediate author Mr. Kelly had then written a book based on the play, and then a further creator associated with cinema houses produced a film based on Miss Brandon's play. One might think that if Miss Brandon had a complaint about that she would probably have potentially decent prospects. But in fact, the case was brought by the intermediate author of the book based on the play, complaining that the film infringed his copyright. Now, it's of course possible that the intermediate author made some form of derivative work and that his creation had been wrongly copied. But it's obviously not a fabulous basis to begin a copyright action, particularly where, as it turned out, the producers of the screenplay for the film had started with the early work, the play written by Miss Brandon. So ultimately that claim failed because the judge held that there was nothing in the film that hadn't also been included in the play. And so there was nothing original for the intermediate author that could be protected. On that basis, it's not particularly surprising. But the case is relevant for today's issue because of a statement made by the judge in the course of giving his judgment, which was the following. So he said, if, for instance, we found a modern playwright creating a character as distinctive and remarkable as Falstaff or as Sherlock Holmes, would it be an infringement if another writer, one of the servile flock of imitators, were to borrow the idea and make use of an obvious copy of the original? I should hesitate a long time before I came to such a conclusion. So with the elaborate language that may have been more commonplace in older judgments, and that was an expression of a view by that judge, or at least the beginnings of a view by that judge, that simply taking a character from an earlier work and then introducing it into a new one would at least lead to long hesitation before there was a finding of copyright infringement. Now, that statement was taken for a long time to be an indication that establishing copyright in characters would be difficult. And it's not a surprise to observe that establishing copyright in something as abstract as a character taken out of the context of the work in which they exist is going to be considerably harder than, say, establishing the subsistence of copyright in the entirety of a novel or in a song or in a painting, for example. But at its root, that comment by the judge in Kelly and Cinema House is really just an observation that manifests the proposition that copyright protects the expression of ideas rather than the ideas themselves. So it's really an exploration of whether character abstracted from the work in which it was, in which it existed, is a work in itself that can be protected. To give you some indication about why you've got this old oil painting up here, that is a painting of Falstaff by William Hogarth. And a lot of my slides are simply illustrations of something vaguely associated with the cases I'm talking about. Obviously, William Hogarth has some connection to my, well, not actually connection other than the name, but to my chamber, so I chose his painting of Falstaff to illustrate things. So that was a case a long time ago. Moving right up to the present, one needs to consider how, in current copyright jurisprudence, one might go about seeking to establish whether copyright subsists in a character. And the short answer to that is that one considers it, which is common ground between the parties in the Shazam case, and which the judge accepted there, in exactly the same way as one considers the subsistence of copyright in any work. And the test for that, which has now been set out by the Court of Justice of the European Union in a number of cases, but most obviously in the Coffermel and G-Star case, is one that arises from the first principles that the Court of Justice has expressed in that case. So as you can see from my illustration, and as you probably know already, Cofmel was a case about genes and the potential artistic work rather than design. I would say from a technical perspective, the potential artistic work in the appearance of those genes. Essentially a case of applied art, the claimants would say. The Cofmel decision made it clear that there is one test for subsistence of copyright that applies regardless of the nature of the copyright in issue. And that proposition, that one applies the same test whatever the work, has its origins in the Berne Convention, which says that protection should be the same for every production in the literary, scientific and artistic domain, whatever the mode or form of its expression might be. The elements of the test that the CJU set out in that case are probably well known now. First, that the work has to be the author's own intellectual creation. So that's the sort of stock phrase that's now used in copyright circumstances. It went on to explain, of course, that in that regard, it's both necessary and sufficient that the subject matter reflects the personality of its author as an expression of his or her, of course, free and creative choices. And as a counterpoint to that requirement, the Court of Justice gave the illustration of an example where that criterion is not satisfied, where the subject matter is dictated by technical constraints that leave no room for creative freedom. There's a second element of the test, of course, which is that protection is limited to elements that are the expression of the intellectual creation, and that requires the protected elements to be identified objectively with clarity and precision. So rules out things like smells, potentially, or other nebulously identified articles or items. So that's now sort of the fundamental proposition of copyright law, at least in this part of the world and our close neighbours. The Court of Justice then actually repeated that proposition in a slightly later case, Brompton Bicycle, not about genes in this case, but about folding bicycles. So another work, again, from that claimant's perspective of applied art. In that case, the court clarified that it's only where technical considerations completely exclude the creative freedom that copyright will not or cannot arise. So that, of course, being a question of fact in each case, it would mean that even where, as in the case of a folding bicycle, the purpose of creating what's alleged to be a copyright work in the first place is to achieve a technical objective, provided that there's an opportunity that's taken to do something creative along the way, then a copyright work can arise. Now, you may wonder, and I had questions when I was discussing this with my head of chambers a while ago, about why I talk about copyright and fictional characters has 2 slides about genes and then folding bicycles. And I include them beyond the fact that the Cofmel case sort of sets the bedrock for the subsistence of rights. Because obviously, in respect of fictional characters, the constraint that something dictated by technical function will not give rise to a copyright work has less obvious application. But in my view, there are still circumstances where that idea, at least, still has application in this arena. So one can imagine, for example, non-creative constraints that might apply to particular works of fiction. And I have in mind as only one illustration that I'm going to attempt of this, a murder mystery story. So one can imagine in a murder mystery story, you're pretty certainly going to need to have one character who appears at some stage of the book who's a victim. Someone needs to get murdered in this story. So one can consider that sort of technical constraint. You're also very likely to need to have a second character, a detective, someone who solves the murder in your detective story, and then perhaps one or many further characters who are potential suspects or actual suspects for the detective ultimately to identify the killer, but for the reader to be entranced by trying to work out the same conundrum for themselves. Now, I talk about those sorts of characters in the context of a technical constraint because at that level of abstraction, i.e. sort of characters A, B, and then C to Z or whatever, there is probably no, or at least very limited, opportunity for creativity at that level of abstraction. But it's still very obvious that the scope to write different detective novels is pretty much infinite. So there's still an enormous opportunity for creative freedom to be expressed within the confines of having various technical constraints, as one might call them, in those circumstances. But in any event, that's the test that one has to apply. Now, before going on to look at how that test was applied in the Shazam case, I'm going to briefly-ish consider two cases that have considered copywriting characters in different jurisdictions without applying that test that arises from Kaufman, or at least without explicitly applying it. So the first of those chronologically was a case in Germany, ultimately decided by the Bundesgerichtshof, called about Pippi Longstocking. It wasn't called Pippi Longstocking, and I'm not going to attempt the German pronunciation of that character's name in the German language, but you can see it on the left-hand side above the image on the old-fashioned book. The character at issue in that case was Pippi Longstocking. The facts were that the claimant was the estate of Astrid Lindgren, apologies, who was the author of the original books. And those books have become very well known, with their chief protagonist being Pippi. There were a number of aspects of the physical appearance of that character that were taken to be relevant by the German court in that case. And whilst, as you can see from the image on the left-hand side, there were illustrations that accompanied the book depicting the character. The case seems to have been put and decided on the basis only of the written descriptions of her appearance that existed in the novels, in the books. And the question was whether that written description of her as a character amounted to an artistic work. So the description of the character in writing that was relied on by the court, and of course this is an English translation of it, was the following. So she was described as this: her hair, the color of a carrot, was braided in two tight braids that stuck straight out. Her nose was the shape of a very small potato and was dotted over with freckles. The mouth under the nose was a very wide one with strong white teeth. Her dress was rather unusual. Pippi herself had made it. It was a wonderful yellow. But because there was not enough cloth, it was too short, and so blue trousers with white spots peeped out beneath. On her long, thin legs, she wore a pair of long stockings, one with bands of colour and one black. And she had on a pair of black shoes that were exactly twice as long as her feet. This is ultimately a fell within the discussion of the Bundesgerichtshof, at least, that this description gave a distinct identification of a particular character. It struck me that the description of her nose as being the shape of a very small potato probably encompassed quite a range of different shapes. And if anyone go to a supermarket and you see loose potatoes, not many of them are identical. But there we are. The defendants in the case produced the item shown on your right on the screen, which was a costume, costumes for children and costumes for adults to use in fancy dress. The costume included a wig, and it included a dress that, as you can see on the image, was green with a sort of pocket in the middle, and two stockings that are both identical, and so are not particularly close to the wonderful yellow dress or the long stockings, one of which had bands of colour and the other which was black. So both with bands of colour there. They were sued. The Bundesgerichtshof considered the domestic case law in Germany, and its conclusion was expressed as follows. It said, separate protection for a fictitious character depends upon the creator endowing the character with an unmistakable personality by means of a combination of distinctive character qualities and particular external features. The test for that purpose must be stringent. A mere description of the external form of a character or his or her appearance will not, as a rule, be sufficient. So, without considering in too much detail what the BGH was driving at there was a dual requirement that it set out. Now, the dual requirement might be necessary in some cases to meet the requirements that the CJU later laid down in the Koffermel decision. But in some cases, those requirements that the German court laid down probably go beyond the now universal requirements that Koffermel and Brompton Bicycle have explained. So, for example, being the author's own intellectual creation and illustrating the author's personality and being capable of precise definition doesn't encompass a requirement for, or doesn't necessarily encompass a requirement for an unmistakable personality or a combination of distinctive character qualities and particular external features. But that was the approach that the German court took. Now, the claimant failed in that case, but not because there was a finding that there was no copyright in the character. The claimant failed because the German court held there was no infringement because only external characteristics, well, I think probably more accurately, only some external characteristics of the character were taken, and none of the unmistakable personality or distinctive character qualities that they held was part of the test. So that was one approach, which maybe if another case of the same nature comes before the German courts might need to be reconsidered. The other case to touch on is a case from the United States. So from the Seventh Circuit Court of Appeals on appeal, I think, from the Illinois courts. And it was a case called, as you can see on the slide, Klinger and the Conan Doyle estate. And as you can guess from the illustrations I've applied there and the name of the Conan Doyle estate, it was a case about Sherlock Holmes, which obviously has some familiarity from the statement in the cinema houses case, where Sherlock Holmes is one of the characters used by Mr. Justice Moore in his examples. So Klinger was another slightly peculiar case, decided in 2014, but it was really a case about whether the Sherlock Holmes character was in the public domain or not. So it arose because the oldest Sherlock Holmes novels had been written in 1887. They were, by that stage, out of copyright in the US because the approach that the term of copyright in the US took to works of that vintage was that they lasted for 95 years after publication. The last of the works that Conan Doyle had written were still in copyright on that basis. And so the claimant essentially his estate and the successors of his estate, alleged that because the characters, they said, characters of Sherlock Holmes and Dr. Watson, continue to be developed through later stories, that there was essentially a derivative copyright work that arose in the later works, which was still in term, and that was infringed by Mr. Klinger's works, which are essentially anthologies. To the extent that the Court of Appeals there made general statements about copyrighting characters, it said this: the more vague, the less complete a character, the less likely it is to qualify for copyright protection. An author could not copyright a character described merely as an unexpectedly knowledgeable old wino, but could copyright a character that has a specific name and a specific appearance. And that was a reference to the facts of a case from 2004, Gaiman and McFarlane, and another case from the 1930s. They went on to say that from the outset of the series of Arthur Conan Doyle stories and novels that began in 1887, Holmes and Watson were distinctive characters and therefore copyrightable. So the case by the Conan Doyle estate failed, again, not because the characters were not protected by copyright, but precisely because they were protected by copyright from the very first stories, and therefore had fallen into the public domain by the time that it wasn't the defendant, I should be clear, Mr. Klinger's publishers essentially sought a declaration of non-infringement, which is why they're the first named party on the case. But they were successful, the allegation of infringement failed. That sort of slightly peculiar factual circumstance is unlikely, although not impossible, unlikely to arise in this jurisdiction or in Europe, because our term is decided for almost all works to determine to end at the end of the calendar year, 70 years after the author dies. So all an author's works go out of copyright at the same point. You're not going to have a sort of successive entry into the public domain. Perhaps with anonymous works, you might have a different approach, but in general, you're not going to see that here. But for our purposes, the US court there was quite clear that copyrighting a character, provided they're not vague or incomplete in some way, can qualify for protection. So those are two cases from other jurisdictions and lead us on to the most recent case on this issue in this jurisdiction, perhaps the only recent case on this issue in this jurisdiction, which was Shazam and Only Fools' Dining Experience. Shazam was the name of the company that to which the rights in the Only Fools and Horses script had been assigned, by which it was exploited, essentially owned by John Sullivan, the late John Sullivan's family. The allegation here was, in essence, that copyright. One of the allegations was that copyright subsisted in the characters within that sitcom. Many of the characters in the sitcom actually were alleged to independently be copyright works. For case management reasons, only the Del Boy character was considered at trial. The Del Boy character being pretty central to anyone wanting to put on a tribute show, and so would ultimately be determinative of whether there was going to be infringement and an injunction or not. The judge there did apply the Coffermel test. So whilst he considered the decision in Pippi Longstocking and very briefly consider the Klinger decision, it was ultimately common ground between the parties that now we're bound to apply the Coffermel test. And he doing so in the judgment, particularly at paragraph 99 and 109, held that the Del Boy character did was a copyright work. Now, in doing so, contrary to the sort of approach that the German court took in Pippi Longstocking. The judge placed little to no reliance on specific external features as a Del Boy character. And one can understand why in the circumstances of that case. Unlike a novel or a book like the Pippi Longstocking stories, where a particular character is described in text, the script written by John Sullivan didn't say Del Boy looks like David Jason, because David Jason hadn't been cast when the scripts, at least, were started to be written. As a consequence, John Sullivan, the claimant's predecessor, didn't create the physical appearance of Del Boy. That was, a natural characteristic of David Jason. He didn't create the physical mannerisms. Again, David Jason didn't create the accent, vocal intonation, and didn't select or create the clothes that Del would wear, because those were picked by people in the costume and props department at the BBC. So it was certainly part of my submissions that you had to settle those to one side, and once you'd done that, you weren't really left with anything that was sufficiently precise to give rise to a character that was protected. Which, as it turned out, the judge did not agree. But the judge did note that within the script there were descriptions of, or at least some references to the manner of dress of the Del Boy character. So there were references to things such as gaudy clothes, but no more distinct than that, flashy clothes. At one point, a reference to him wearing a loud blue suit. And it does appear that the judge placed some reliance on those aspects of the script to say, well, look, John Sullivan was thinking more broadly about what this character actually looked like, and so I can take that into account in setting up the concluding that copyright does subsist in the character. The defendant in that case put on an interactive dining experience. Apologies. Essentially, what they would do, they would hire out ballrooms or big dining halls in hotels around the country. Attendees, guests, ticket holders would arrive, and they would be given some welcome drinks. And whilst they were given welcome drinks, amongst them would circulate actors dressed, as you can see here, dressed in the sort of sheepskin coat, or dressed in a camouflage jacket. You can see in the character that many of you may recognize as being a mimic of the Rodney character from the sitcom. They would then have a 3-course meal served by these characters, through the course of which an interactive story was told. So the premise of it was that it was a night at the Nag's Head, the pub in Beckham that the Trotter brothers would visit, and but beyond that, an entirely new story was written about them needing to get hold of some money for a particular purpose, and they did so by running a pub quiz. I understand it was very well received by the people who went to it, but did use some sort of catchphrases from the sitcom. So the Del character would say things that it was familiar that the Del character in the sitcom would say, like lovely jubbly and pushti and words such as that. And was also the vocal intonation, even sort of apparently manner of movement of David Jason, was mimicked by the actor playing Del Boy, and likewise by the actors playing the other characters. So what one can see from this is that there was obviously some great effort made by the defendants to seek to mimic the appearance and sound of the characters. But the appearance and sound of the characters, I mentioned earlier, shouldn't be something that gives rise to infringement, where those were not things created by the copyright owner. So to the extent that I'm going to express one complaint about the judgment during the course of this lecture, is that when the judge left the question of does copyright subsist in the Del Boy character, and went on then to consider is there infringement by the acts the defendants are undertaking, there's a noticeable disconnect between the things that he relies on. So rather than, I think, be entirely conventional, and it would be heretic to say otherwise, rather than saying, well, what I must look for in a finding of infringement is that the defendant has taken those things, sufficient things which give rise to originality in the work relied on. The judge said, well, I can see here in what the defendants are doing that they want to give a pitch-perfect imitation of Del Boy. They want the character to look as close to Del Boy as possible. And therefore, in a sort of very brief part of the judgment, he held there was infringement. Now, slightly earlier in the decision where he was discussing the law, there are hints of that disconnect already being part of his thinking. Because at paragraph 86, he cited a passage from Coppinger that I was quite keen on because of what it says, where characters from the film are copied, borrowing the name and other identifying features that without detailed plot or dialogue, a claim for infringement of copyright is unlikely to be successful. I said, yes, look at this case. That's exactly what we do here. But the judge said that seems also, it was in common with another submission I'd made, also to be focused on what may or may not amount to infringement, rather than being concerned with the issue of whether a character from a novel or dramatic work may be protected by copyright. And I would say my complaint is that you can't separate those two things. They're necessarily two sides of the same coin. You can only have infringement if you take that thing which gives rise to the work being protected by copyright in the first place. But there we are. There was no appeal from this case. All I can say is that after the judgment came down, there was a confidential settlement, which was perhaps an offer so good that my clients couldn't refuse. Now, other defences. So having got to the unfortunate position of the judge saying, well, there's a copyright work here and prima facie your clients have infringed it, there was attempted reliance on what's now a relatively new defence, in the UK legislation at least, of fair dealing with a work for the purposes of caricature or parody or pastiche. We didn't rely on caricature, but said parody or pastiche. That work, one might think, that defence, one might think from looking at the language of the Copyright Designs and Patents Act, would on its face have two elements. One being that there's use for the purposes of parody or pastiche or caricature, and the second being that the use is fair dealing. But things are not quite as straightforward as that in a lot of IP laws. I'm sure you'll be familiar. There are hidden depths, with the UK statute really being some sort of code for underlying principles that come from different sources. We wonder why I have a sort of MC Escher type image here. This, again, slightly oblique picture is a lot of steps in the Federal Palace in Bern in Switzerland. And I included that picture because the UK statute being code for something is ultimately code for what's known as the Bern three-step test, which comes from the Bern Convention, at least via the Article 5 of the InfoSoc Directive, or Copyright Directive, whatever you want to call it, 2001/29. Which obliges national legislatures to limit their defences to copyright infringement only to circumstances that meet this three-step test. So the first of the steps being that the exceptions apply only in certain special cases. Secondly, that they may only apply where the permitted activity that would otherwise be infringing does not conflict with the normal exploitation of the work by the copyright owner. And then thirdly, does not unreasonably prejudice the legitimate interests of the copyright owner. And you can see this on most factual circumstances is going to be a bit of, if not perhaps almost complete overlap between the last two of those aspects. So the certain special cases, dealing with that first, it identified in the National Register. You see, if I go back through my picture of the palace, Federal Palace in Bern, to the fair dealing defence for parody and pastiche, the special case here is that the use is for the purposes of caricature, parody, or pastiche. And you see similar equivalents in all the other fair dealing defences that exist under the Copyright Designs and Patents Act. So, for example, fair dealing for the purposes of reporting current events is a special case that can fall within the Bern three-step test. And I'll say some more about that in a moment. The question of what amounts to for the purposes of parody or pastiche has been addressed in English case on a different issue called kickstack that you find cited in Shazam, where it talks about for the purposes of and what that means, and it essentially holds that it just means as part of an exercise in. So there's not really anything magic about for the purposes of. It just means you've got to be using a work as part of an exercise in parody or pastiche. What then, turning to the two different types of act that were relied on, sought to be relied on in the Shazam case, what does parody mean? How do you get within that as your special case? The judge in Shazam set out that essentially from a sort of dictionary or commentary definition that a parody was an imitation which exaggerates the characteristics or a work or a style for comic effect or applies it to an inappropriate subject. And dealing with pastiche, again, from a dictionary definition before he looked at it in a more legally analytical way. A parody was a medley of various things, specifically either a picture or musical composition made up of pieces derived from or imitating various sources, or a literary or other work of art composed in the style of a well-known author, artist, or other creator, with the effect of copying or imitating the style of that other creator. So before I come on to how the court treated those aspects, considered whether the use by the defendant in the Shazam case was either a parody or a pastiche, before he went on to consider the second and third aspects of the Bern three-step test. And spoiler alert, he held that none of them were satisfied. I'm just going to touch on the only decision of the Court of Justice which deals with the defence that arises from the Copyright Directive. And this was a case called Deckman and Van der Steen that dealt with the parody defence. Now, Mr. Van der Steen had created a lot of children's books where the two protagonists was in his language, Suske and Wiske, who were Spike and Susie in English. And the case concerned the alleged infringing reproduction of the cover of one of his graphic novels. And you see his cover on your left. There was an image of a sort of character flying above a town square, dropping coins that were collected by people in the town square. And you see at the bottom right the two characters, Spike and Susie, sort of looking on as this happens. The alleged infringing image, which you see on the right-hand side of the page there, was one created by or for Mr. Deckmin, and it was the cover of a calendar produced by the judge described him as a Belgian nationalist anti-immigration party member, or for at least for that party. And what it depicted was the then mayor of Ghent, who you see without the hat on the right-hand side, with a rainbow sash around his waist, dropping coins into the market square where they were being picked up by people wearing veils or other dress associated with people who follow the Muslim faith. And I think that presumably the message that image was intended to pass was a criticism of the incumbent mayor for assisting or permitting followers of the Muslim faith to settle in Belgium, and perhaps for supporting or sympathizing with the LGBTQ plus community. So the estate of Mr. van der Steen were unhappy with this, and so they sued for copyright infringement. And in the Belgian courts, they were successful, but the case was referred to the Court of Justice with a number of questions about what the parody defense required. And there were a number of factors that in its question to the court that Belgian judges sought guidance on. They asked, for example, whether it was necessary for the work that was alleged to be a parody to parody the original work. So whether here I can use a work to parody something else. And the answer to that was very clearly, yes, you can. You use a work for the purposes of parody, not only if you use it to parody the original, but also if you use it to target some third party. And that, I think, must be right. Another question they asked was whether the new work itself had to be original. The answer was no, it didn't. And thirdly, well, as one of their questions they asked, whether the new work had to be identifiably the work of a different author. Again, the answer was no. What the CJEU said was that the alleged parody had to evoke the existing work, but be noticeably different from it and express mockery or humor. Now, in Shazam, I sought to persuade the judge that there you were. That was, in essence, something like a statutory test. And if I persuaded him that the defendant's dining experience show was something that evoked the existing work, we said yes. But was noticeably different from it, we said yes. And was an expression of humor, we said yes. But there it was. It was a parody. But he held, and I say I think rightly, he held that just fulfilling those criteria that the Court of Justice identified was not a sufficient basis to saying that your work is then a parody. So the Court of Justice were not giving a list of sufficient conditions to say, if you meet these three things, then this is a parody. They were simply saying that these are necessary characteristics of a parody. But it follows, certainly from the judge's finding, I think it follows logically, that you still must be doing something which is a parody, with those particular characteristics. So ultimately, to parody, one's got to express some opinion by means of the use of the original work. And I think cases like Deppmann and Van der Steen are actually really pretty straightforward, where there's something that's obviously intended to be some form of political commentary, using a work in order to poke fun at a political character, whether you agree with that proposition or not, is used for the purposes of parody. And obviously there's a high level of protection, although there must be a balance struck between the rights of the copyright owner and the rights of someone seeking to express themselves. There's a high level of protection given to people who are exercising their right of speech, particularly when it's political speech. But seeking to, as we were in Shazam, seeking to kind of expand that defense to allow a comedy dining experience, which wasn't really making any comment on the world around us in any way, was perhaps a stretch. I was much more keen on the pastiche idea, that this show of the dining experience took aspects of the sitcom that John Sullivan had created and assembled them together in an entirely new story, mimicking John Sullivan's style to be a pastiche. As I've already indicated, the judge didn't agree with that. In particular, his approach to what amounts to a pastiche was a very considerable nail in the coffin of that defense for my clients. So he held, flowing from the Byrne three-step test and the need for, I'm going to try and go back quickly to that, the need for the exceptions to copyright infringement only to apply in certain special cases and not to conflict with the normal exploitation of the works and not unreasonably prejudice the rights holder, meant that the defense would have to be construed narrowly so that it wouldn't become a general fair use defense. And he held that was necessary to confine it to a special case rather than just, using it for any form of imitation of an existing work. So his criteria, so they look like there are three. He said, my two criteria are these A, B, and C, but when you look at it rightly, because A and B are either or, so they're one. The use imitates the style of another work, or it's an assemblage of a number of other works. But in both those circumstances, the product must be noticeably different from the original work. Now, our contention had been, well, the dining experience is noticeably different because it tells an entirely new story. It doesn't sort of exist in the Only Fools and Horses John Sullivan canon. It's an entirely new work. But of course, we were also arguing that Del Boy himself was not a copyright work. When the judge holds, well, your main character is itself a work and you've reproduced that work, then in fact, we haven't made something noticeably different. We, on his view, deliberately set out and necessarily set out to reproduce that work in a way that was as close as possible to it rather than being noticeably different. So for at least that reason, he held we weren't entitled to rely on the pastiche defense. So we fell at the first hurdle on both parody and pastiche, and something which I won't go into now given the time. We also failed on the other two aspects of the Byrne three-step test. So it did interfere with the normal exploitation of the work because Shazam wanted to put on a sort of were putting on a West End stage show. And he held that would be interfered with. And he also held that we were unreasonably prejudicing the rights holders' interest essentially for the same reason. So sort of rattled through things a bit at the end. I know we've already probably reached our hour after we started, but if there are any questions from any of you or any of the people around the world, then I'd be happy to try and deal with